Hello viewers and welcome to Daily Politics on Trust TV. On this program, we discuss issues around politics, policy and governance. I'm your host, Hamza Idris. On September 6, the Presidential Election Petitions Tribunal in Abuja delivered judgment on the prayers raised by the People's Democratic Party and its candidate Atiku Abubakar, Labour Party and its candidate Peter Obi, and the Allied People's Movement, APM. Even though the judgment in summary upheld the victory of President Bola Ahmed Tinubu of the APC in the February 25 presidential election, and of course, petitioners have since announced their intentions to exercise their fundamental rights of appeal to the court of the land, the Supreme Court. Some people have expressed concern over the lengthy and bulky nature of the judgment delivered, even though many others applauded the justices for taking their time to justify why they took certain decisions. Recall that the panel of 5 justices, led by Justice Haruna Zamani, took over 12 hours to read out the content of the verdict, which is 798 pages long. Some legal luminaries had expressed worry over the nature of the court judgments in Nigeria, citing it as one of the reasons why it is difficult to interpret by citizens without help from legal practitioners. Tonight on the program, we'll be speaking to one of such legal practitioners, Barrister Umar Aminu Kalgo. He is the Secretary of the Nigeria Bar Association Birnin Kebbi branch. We also have his take on other cases at various tribunals in the country, including Kebbi State. He joins us virtually from Birnin Kebbi, the state capital, and will be sharing his perspectives on these issues and more. Welcome to the program, Barrister.
My pleasure to be on the program. Thank you.
We're happy having you. We'll take a short break, and when we return, the conversation with the barrister commences. Don't go away. Back. Yes, Barrister, let me start by asking you on your take on the judgment delivered by the Court of Appeal. I mean, the Presidential Petition Court, which upheld the election of President Bola Tinubu. What is your take on that?
Good evening, viewers. First of all, I would like to say the Presidential Election Petition Tribunal have delivered its verdict, and that verdict is binding on all in the nation. So all I have to say pertaining to the merit of the case is that it is a subsisting judgment, which all must agree with at this level. But on the issue, because specifically the issues you raised about the lengthiness and the duration of the time for the reading of the judgment is another thing altogether. Yeah. And it is on that area or factor that I have written an article. Yes, I can hear you.
Yeah, go ahead. You wrote an article, you said 2023 judgment, yeah.
Yes, the article is titled is more or less concerned with the nature and the lengthiness and the duration of the hour. And that article is titled 12 Hours Reading of the Presidential Election Petition Tribunal 2023 Judgment, a symptom of unsustainable form or style of writing judgment against practicality and reality of the digital world of today. So this article had raised a lot of issues that are a lot of people are calling me and we are having discussion on it. So as much as I can say about the substantive and the article I have got.
Okay, why did you pick interest in that area, the form and style of writing of the judgment?
Well, my reason for taking an interest in that, I know many people doesn't have any worry pertaining to the judgment that was read over 12 hours. But I have an issue with that, considering other laws and documents, because look at it, even the maximum hours work per day internationally and in some of the United Nations conventions is 8 hours. When you look at the International Labour Organization standards and also 2 conventions of the United Nations regarding working hours per day, it has said this clearly. There is hours of work convention of the United Nations which refers to industry workers in 1919, which specifically provided for 8 hours. And there is another one which provides for commercial and offices work, and it's also for 8 hours. Let me bring another angle to it.
Yes, go ahead.
There are a lot of pictures. That shows a lot of our legal luminaries in courts dozing off, slumbering. You see pictures of journalists, distinguished journalists in their field. You saw them slumbering. You also see some other dignitaries who were in the court gallery or in the bar. And these pictures were all across the social media. When you look at these pictures, though they are seen in lighter moods as comical traits, you can't help when you watch them to feel the instinct of laughter. But overall, it is not saying good news to those people that you will see. And I think it goes beyond that, even to the country. But when you look at that and you now subject that these people have been there for over 8 hours, especially journalists covering it, or the court personnel that were there all through. So this call for, it gives a call for what already prior to this, lengthiness of judgment have been an issue in the contemporary world.
Okay.
Even in Nigeria, we can cite some examples to that. Yes.
Okay. Now, is it really a problem for justices to take their time and discuss technicalities and other variables around a legal issue, for them to bring out everything for everyone to see and to understand why they take certain decisions?
You see, we are not blaming. Okay. You know, the world always advances, and there are traditional ways of doing things. So I want to bring, even in the UK, there is this concern about lengthy judgments, that the President of the Supreme Court of United Kingdom had in several times provided talks in papers where he raised concern about the old traditional way of writing judgments, which is lengthy, which is cautious, that we need to depart from that.
Okay.
And talking about lengthy judgments, when this judgment Judgements searches across the world, and India, that are having, because in India we have judgments that are even up to 400 something pages,
yeah,
and others. The Lord David Nuremberg Kingdom Supreme Court has paper he presented. No, I want to cut a small part of.
Okay, go ahead.
It should not be taken, if I may, it should not be taken to excess. Judges should weed out cautious. We should, for instance, remove unnecessary display of learning, or what Lord Chief Justice recalls his history teacher as saying, APK, unjust parade of knowledge. Let me be very brief on this.
Okay.
And even in Nigeria, it has been a problem that in 2019, the Nation newspaper has to an article which read, how lengthy should a judgment be? And this is a Nigerian newspaper that was published on 24th September 2019. So you see, the current trend of the world is moving from the traditional way of writing judgments to a more, I'm referring to these articles because they have profiled solutions on how to go about it. In the Nigerian paper I cited, The Nation, that article was covering a discourse on law that was held under the second Babalola Dictionary of Judicial Defined Words and Phrases. So in that program or activity, this came as an important thing to discuss in that respect. So when you look at this, and bringing the earlier question I raised about people slumbering, you see, it is not saying good. Sleeping on duty is under labor law is a misconduct, which can even cause someone to lose his job. So now, when you look at those legal luminaries, the court personnel, and your colleagues that are there to cover the judgment, slumbering, is it saying good? When you think of it, you imagine, can they be subjected to what? A charge of that sleeping on what? On duty? When they have been there for over the maximum time of 8 hours. And this 8 hours included the breaks, rest breaks that a worker is supposed to have, which differs from country to country. So these are issues that I would have to say that are there. And the issue of the style of writing judgments, even in India and the UK, is all over, is there. And there are a lot of articles which I have cited in that judgment. For instance, one of the justices of the Supreme Court of India has this to say: it is the need of the hour to write short judgments which can be understood, which can be understood by litigants. So these are some of the issues I raised in the article, and believe you me, I have received a lot of responses, and the majority of responses concur with the issues I have raised, and also a lot of the things they saw that are coming from these countries. Because there is an Indian article also that make a comparison of the judgments that are so fundamental that occurred in the US and UK, and give the number of their pages. While you find the pages are within reasonable, span. When you come to our countries, specifically Nigeria or India, you find the pages going far and far.
Okay, what do you think?
That's the Nation's article, which says how lengthy should the judgment be, which was from the Nation newspaper of 24th September 20.
Okay, Barrister, it appears that you have interest in this area. Have you checked to see why our judges in Nigeria take time to put almost everything in writing before they get to the courtroom? Have you tried to find out some of the factors so that you can share them with us?
I didn't get your question. Please, can you take it again?
Yes, I said every country, has its peculiarities. In Nigeria now, we have justices taking time to write lengthy judgments. Have you tried to find out what are some of the factors responsible for this?
Well, what I would say, I think I am a practicing lawyer, and I go to our courts and I see the judgments, and I am familiar with the traditional way of writing judgments, where the judge will take time to bring the arguments of counsel. So that's why I'm referring to that article, because in that article of 24th September 2019, The Nation, some of the speakers, whom are all leading legal luminaries in Nigeria, some of the things they raise is the issue of the bulkness of the judgment will come from these legal arguments that are reproduced, that are from counsel, that are from lawyers, not necessarily the findings and reasoning of the courts.
Okay.
That's why in the judgment, it's at the tail end that you come to see this. But what I want to say is, the judge is in command of the courts and where judgment is going. For example, the parties can raise issues, but at the end of the day, it is the court that will streamline these issues for determination, narrowing the ball of contention which the court feels will determine the matter ultimately. Even in this judgment we are talking about, you will realize that the part which form even the revision over the facts is not the one that takes the much of the bulkness of the case, but rather the arguments. And arguments, not all arguments matter. I see maybe in our lower courts here, like in the north, the Sharia courts, the lower courts, they have a specific way of doing their judgment, which I think can be explored in trying to limit the lengthiness of pages. Because after all, there is record of proceedings of whatever transpired before the courts. So this Sharia courts I'm talking about, they always come to judgment and they start with the findings of the courts when it gets to the merits, with the findings. And after the findings, they just relate them to some of the issues that are legal issues or issues for determination. But when you say that all the arguments of counsel must come in, I know there will be a lot of differences and debate about this. But what I'm just saying, it is not sustainable to have a judgment that will surpass the actual working hours that the law permits. It does not, common sense is something that we work and know. There is a saying that good laws, common sense make good laws. And for that reason, in law, there is this concept of reasonable man. And this reasonable man is a hypothetical person that the law created to see how he would act in a certain, what conduct will he exhibit in a certain situation. So for example now, for me to put this question, starting with you, Mr. Hamza, I don't know whether you were at the judgment, if I may ask.
No, I watch it from the office.
Okay, no problem. Now, what I just want to ask, prior to the judgment, was it within your contemplation that this judgment will take this limit of time? Averagely, were you in your wildest expectation?
Well, maybe I should now take the question back to you. That is it normal?
Sorry, if you are not comfortable with answering
it's okay. Maybe,
Now,
yeah.
Imagine,
Yes,
imagine
barrister.
an average Nigerian.
Yeah, barrister, is it normal?
Imagine an
Okay, well, is it normal or is it out of place for judgments to be consolidated? Because I think what we witnessed on that day was that the justices brought together their findings on petitions from at least 6 interested parties or more.
three.
No. I'm saying now
Yes.
PDP,
Three petitions.
its candidate, right? If you put it, that is 1. But if you are treating them separately, that is 2. You have Labour Party and their candidate, and then you also have the APM. Is it out of the norm for justices to consolidate issues that actually are intertwined so that they can decide them together?
Consolidation is allowed. And it's there are areas that the courts will find that consolidation is the best way to go. And consolidation, the parties can apply, and the court suo motu can even direct that cases should be consolidated. That is standard. I am fully aware. That these are 3 petitions. But all I'm saying, the span of time justified. From my own point of view, if it is the consolidation that warranted this judgment to go up to this length, then I would say, in my own view, it would have if maybe the matters were not consolidated, we will not have to to take judgment after that. It would have been a good. I just so much look at the actual time that was spent in court. So I'm just saying, now look at the average Nigerian in Abuja, in Enugu, in Kano, you think, where are they thinking of a judgment? So, this is something that you can imagine.
Yeah, then something closely related to this is there any way we can isolate lawyers of these petitioners from the quagmire of sort that we found ourselves? Because if you look at the prayers of councils to Atiku and PDP and the Labour Party, and then if you put them together, they are quite a number. And these justices there are many, right? The prayers. The prayers by PDP and its candidate, Labour Party by its candidate, and then APM. Quite a number. And these justices, they took turns to now expand on most of these issues, because I cannot remember after the judgment if any Nigerian or anybody said that there is an area which the petitioners prayed to have a redress that was not addressed. So is there any way we can isolate the contribution of lawyers to these lengthy judgments?
Look, you see, speaking about the lawyers, well, we all have a duty to guide the court, to bring to court, to limit and have interest in attaining justice. That said, you see, every lawyer is trying his best to protect the interest of his client. And these interests of protecting clients may come in the way that lawyers may make a lot of submissions and what have you that will be maybe odious or in trying to protect their that one is as it's fair, but all the same, that duty for lawyers to have interest in justice is ultimate, and I believe there is a room for lawyers to play. And on this, I want to say, even the rules we have, it should not be a one-way thing. Even the rules we have that guide election petitions, they limit the pages to which a lawyer can write addresses. And you see, Therefore, the issue of lengthy or what is also in the contemplation of the courts, because like the rules that were made for tribunals by the President of the Court of Appeal for this 2022, it limits the pages of addresses. You can't go beyond 40 pages unless you have the leave of the court. So this factor is there. So if it is for the lawyers, I think even the judges should have a look toward this pertaining to the time, because ultimately the laws that limit the hours for which an individual should work per day, they are not there for nothing. Extortion is natural. Yes. So that's why when I saw the pictures of the learned self, dozing off is pitiful. It raises laughter, but it also raises another issue that I think we need to look at.
And is it right for me to conclude that lawyers are the architect of their problem? Because they were the ones complaining. I saw a lawyer of the ruling party in the court also making observation on that day, saying that why can't they just say that all petitions sacked or something like that, and then the lordships, they had to now, ask him to take back what he said. Are lawyers not the architect of their problems, asking all sorts of things that have no relevance to the judgment?
I want you to look beyond lawyers.
Okay.
The election petition judgment is not just about lawyers. It's about Nigeria. It's about the laborer on the road. It's about the market woman. It's about every other person that voted. This said, it should not be the lawyers that should dictate, everything. And I can't to agree that lawyers are the creators of the problem. I think it will be, for me, I don't agree with that, because I think the lawyers are the judges in their wise and elevated position. It's just that in Nigeria, we are not used to bringing these opinions. Let me say sincerely, the reason why I wrote that article, and I asked people for you to assess properly, reading the article will help. The main reason I did this is in utmost, patriotism to the, reputation of my country. I want everything that emanates from Nigeria to be humane, to be world class, so that, because even the pictures of the learned counsel sleeping, I didn't feel happy about it, because wherever a picture goes and shows a senior advocate of Nigeria sleeping in court, it doesn't sit well. But then I look at the extraneous hours they were in court, and now that's what prompted me to go and see what limits are there for a person to work, and it is 8 hours. It's not out of nothing. Yes,
all right, thank you very much. Yes, we'll go on a break, Barrister. Yeah, thank you. And because we've been with Barrister Umar Aminu Kalgo, we'll go on a short break, and when we return, the conversation with him continues. Don't go away. Welcome back. If you are just joining, you are watching Daily Politics on Trust TV. Do well to follow the conversation across our social platforms on Facebook, Instagram, and watch us live on YouTube. I still have via Zoom from Birnin Kebbi, Barrister Aminu Umar Kalgo. He's the Secretary of Nigeria Bar Association in Birnin Kebbi. Welcome back to the program, Barrister. Yes, I am actually taking it on lawyers today. We have over 500 cases across Nigeria deciding gubernatorial, National Assembly, and State Assembly, House of Representatives petitions. Why do you think we are having such a number of petitions across Nigeria after every election season?
First of all, to decide why are we having them, I think it's a call which definitely I cannot answer, but I can look at certain things.
Okay, go ahead.
Because, every individual will have his very reason for going to court. But you cannot take it from that he must have a grievance that he believes if he approach the doors of justice, he may secure a right or an obligation that he believes that he is entitled to. That's why people come to court. But the sheer number of the cases is another issue. And I think in Nigeria, what we need to find a way is, I don't think it is bad for people to have, to feel, that they should approach the courts. I don't think it's a bad thing, but it shows that there are a lot of people who have grievances in the exercise of the election that took place. Nothing, no more, no less, I can say. But the fundamental question is for Nigeria to look at best ways to address these court cases if they can to the court. I think that's the fundamental issue, because how can we anticipate to have something that will prevent people from coming to court? That will not be good for justice. The doors of justice should be open, and that's ultimate when it comes to justice. It is for the system to be able to handle what is coming towards us. And I think that's another question, because the number of cases, the overload of cases and how they are conducted in Nigeria is another question, which I think a lot of ideas and concerns are being raised on this every time. Even at the last concluded NBA conference. Yes, this issue came up, and a lot of people have shown their ideas on how best these things could be addressed. Okay. This is what I can say.
Yes, the reason I raised this question is that many Nigerians believe that lawyers, in their wisdom, advise their clients to go to court even when there is no need for them to go to court. A client will approach a lawyer and say, this is the issue. And the lawyer knows that he has no case, but probably because of the legal fees or other peculiar benefits, he will tell the client that, yes, you have a case, you can go to court. Is this really ethical in the legal profession?
First of all, without attaching this scenario to any particular legal practitioner, as you said, it is not ethical for a lawyer. When a lawyer advises a client, he should do it with full integrity, and he should tell the client the likely strength and weakness of his case. That's why in our rules, like the Abuja FCT High Court rules, it provides, before you file any case, that should be in writing in the proceeding, particularly if it is a writ, where the lawyer will now, attest that he has surely informed the client as to the nature and even the strength and weakness of his case before taking this brief and before taking direction from the client to institute the case. So I would say, well, for a lawyer to act in that manner, it's very, very unethical. I'm speaking in general terms.
Yes, you are the secretary of NBA in Birnin Kebbi. How are you handling the issues of discharge and bail lawyers? And I think it's closely related to the question you just answered, where they create problem, they create scenario where there is none, and then they are deployed to go to police stations or to go to courtrooms. How are you handling such people in your jurisdiction?
Well, I would say in the NBA Building Heavy branch, really I would say we don't have much complaints. It is very minimal, the complaints we get from clients against certain legal practitioners. Very, very minimal. But all the same, the coinage charge and bail lawyer is a coinage that is in Nigeria. And I think the coinage charge and bail lawyers is something that is attributed to certain people who mainly their practice is within the law enforcement agencies, where they go and they go and apply for bail through those. So I'm not. The reason why I'm not comfortable with this coinage of charge and the lawyer, I know it is a coinage, a phrase that it seems a bit, I would say it is derogatory, because any lawyer that you call charge and the lawyer, I know you will not take it lightly. Yeah. So it's a coinage that even from the very instance it was made, it was referred to certain people that are not, doing what they are supposed to do. So I don't think it's not a proper context, but it's there for this purpose. I would say is
I actually represented the thinking of majority of Nigerians. You know, this is how they see.
I know.
It's just like in our profession in journalism, we have what we call quacks, just like medicine and all that. You have people who bring a lot of backlash, to your profession, and we always try to see how we address such issues too.
The issue of charge and bail lawyers, you see, anybody who went to anywhere to bail someone, you see, he is coming from the side of seeking for liberty of certain. I think maybe you are talking about the complaints.
Yes.
Maybe some people that raise the complaints. Really, there are situations where lawyers will write to law enforcement agencies on a case which ordinarily should be a civil matter, but they now take it to law enforcement agency, who in turn regarded them as criminal. Yes, there are such situations, but I want you always to look at whose responsibility is to prosecute before the court. Or to arrest before prosecution. It is the law enforcement agencies. And the problem is a lot of law enforcement agencies, they are, in terms of lawyers, the personnel are not enough. They don't have enough lawyers to advise accordingly. I think this can be solved when we have the law enforcement agency having adequate number of lawyers, because they are the ones to vet a case, to know whether it should be a civil case or a criminal case in the first place.
And and what is the relationship between the bar and the bench in KB, especially in the aftermath of the elections we held earlier in the year? Because it's like almost every chair or every seat is being contested. Of course, we know that Alero and Bagudu, they are there in the court. Usaini Kangiwa and Malamawa, they are there in the court for KB North. We have Maidoki and Balana Allah still in court for KB South. And above all, we have Aminu Bande challenging Governor Nasiru Idris and many other cases for the State House of Assembly. How are you coping? How are you coping with this, number of litigations?
The election petition in KB, there are two. You have the National and State Houses of Assembly Election Tribunal, and you also have the Gubernatorial Election Tribunal, which have only one case before it. All the other cases you are taking in the National and State Houses of Assembly Election Petition Tribunal, they have 11 cases and 11 petitions. I know. I was involved in one. And most of the cases before the national and state houses of assembly election petition tribunal have been decided. I was personally involved in one of these petitions. That is the petition of which has to do with Bagulosu federal constituency, and the judgment have already been, the verdict of the court has already been given, and some of them, we have even some that lost that are not even willing to appeal the cases. So what I would say, it is going well. It is going well. It is important. Everything is going well. As to the verdicts, the judgments, where who won, who lost, I think that is something that every judgment subsists, and it should be the position of any other person once delivered. Anybody who is admitted can then go on appeal. So this is much I would say on the issue.
But can we say we are having? Can we say we are having real democracy in Nigeria, in a situation whereby you have over 500 cases across the country, and most of these cases will be validated by the courts instead of at the ballot arena? That politicians believe that only judges have the wisdom to say that yes, you have won, despite the fact that a certain number of people voted for you. As a legal practitioner, is this really ideal for a country, a nascent democracy like ours in Nigeria?
It's good we have the bigger picture of democracy. I would answer your question. I believe it is a healthy democracy to have this kind of situation. The reason why I said so is even the courts to be liberal, to accept and adjudicate is also an exercise of a democratic, avenue that you find in democracies. Let me give you an example. There are countries where you find that they have dictators. You will find that a single person is contesting and nobody can even go to court. Where you find, dictatorship and you don't find freedom, nobody will have even the opportunity. Or you find a person standing, nobody contests with him. Such kind of things. All in all, what I'm saying is really, these cases are saying something about the electoral process. And now the courts are vindicating. If the electoral process have problems, in certain cases, the court will show. And in certain cases, it will vindicate the electoral process. I think we should look at our democracy, look at its age and where we are going. With the current situation, under 20-something years when we start practicing this, I believe as the electoral process becomes stronger and steady, the cases will soon be going down. Look at American system of government. All after 200 years, during Trump, we are having some issues. The president himself accusing the electoral system, which far back, all my life, I have not had that from the American system. But it's still a democracy. So I think let's have the bigger picture to know that even for the courts to work accordingly is also part of democracy. And these people that are coming to courts, what are we to do? The only other option is to prevent them, to have something that will prevent, and I think that will not be democracy. So I think it's just for our system to work proper. I will be happy if we have courts that can dispense with these cases timelessly. I think it will save a lot, and we're experimenting.
And is it really our electoral act has got it right that it provided 180 days for electoral issues in the aftermath of election to be decided. Now, this, we have few hours now, I mean, to exhaust this 180 days. But quite a number of cases are still there at the tribunals. Where did we get it wrong? Is it that the lawyers or their clients are not getting it right? Or is it that our lawyer, our judges are overburdened?
Mr. Hamza, what I want you to understand, these days that we are given are for specific levels. Like for the 180 days you talk about, these are days for the tribunals at their first instances, like the National Assembly and State Houses of Assembly Election Tribunal and the gubernatorial, they have that time. But after, within that 80 days, if they exhaust, and if matters raised to the Court of Appeal, there's another time that will start counting for them, within which also to provide this judgment. If I may not wrong, 90 days, if I recollect correctly. So even with this presidential election tribunal, it was made within time. Now, those who appeal to the Supreme Court, it has the time within which also to deliver judgment. So we are not saying there's none of the election petition that was behind schedule in delivering a judgment, and we cannot have that. Even in the 2019, we don't have such things like that, because I'm very strict in observing that they do deliver judgment within those times as far as the election petition tribunals and appeals that have to do with election petition are concerned.
Then what is the implication of this? And I want you to look at it briefly in two ways. Number one, to the politicians who take a large chunk of their time pursuing cases in the courts. Do they have the luxury or the even space to deliver services to the people? And then on the side of the justices, what is the implication on this, on addressing other cases, criminal cases, marriage, inheritance, and all that?
Yes, first of all, pertaining to the politicians, politics is a very vital aspect of life, and always they are at the highest echelon of society, where they manage the affairs of their fellow human beings. So there's no time that the office of a politician is very light. It is always very heavy. And in that regard, I would say, even if you take out this issue of election tribunals, the politicians definitely would have tight schedules on other things. If you call it a distraction, yes, it is a distraction, but a necessary one, which we have to leave, because to allow people to ventilate their grievances in court is very, very vital to the well-being of whatever society you think of. So it's just something that we don't have any luxury to go out of it. So the politician may as well just have to live with the distraction of court cases where they happen to be filed. I think there's no two way about that. And the other issue that you talk about, maybe the election petition cases, taking the time and or I can say distracting the judiciary from other causes, other cases relating to all other things, because these ones are time bound. That is a reality. And this brought us to the other question, which I see is another aspect, whether our system, the judicator, the judiciary system, because we have a heavy backlog of cases, especially when you think of the Supreme Court. The system really, if you look at it, I talk about unsustainability about the time of judgment. I think even our system, we need to check it, because cases coming to Supreme Court are having ordinary cases you talk about, are getting days to be had in 2 years ahead. And this, you see, is telling you about how cases are truncated at that level. So the way I see it, definitely it is adding to the law and it is increasing the backlog. But for this, we need a system review. We have to review our judicial system, I believe, to decongest these cases before they are teaming up. And it's far-reaching because it has to do with constitutional reforms, I believe.
All right. Thank you very much, Barrister Umar Aminu Kalugo. I wish we have more time to discuss quite a number of issues.
My pleasure.
All right, we have to have you some other time, and thank you for your time. And viewers, that's a wrap on today's package. We sincerely hope you found the conversation engaging and informative. And be sure to join Daily Politics Live, airing every weekday, and also our special package on Friday, during which we open our telephone line for you to comment on national issues. Once again, we thank you for watching. Bye-bye. I'm Hamza Idris.